Our first speaker tonight is Manoj Dias-Abey. He is a labour law lecturer at the University of Bristol, covering issues including international labour law and migration. His research interests include labour organisations and their use of strategic litigation, temporary labour migration programmes, and regulating working conditions in global supply chains. One of his current areas of research looks at the law and political economy of temporary labour migration programmes. He is the racial equalities champion at the law school, and he also chairs the working group on decolonising the curriculum. So a very busy man. Thank you for taking the time to come and speak to us tonight. Manoj, I was reading your blog on the IER's website just this morning. Talk us through some of the issues you raised in that very interesting blog.
Thank you for that introduction and the invitation to come and speak. I'm a big admirer of the IER, so it's a real thrill to be asked to come and speak at one of these events. So my brief today is to sort of quickly outline the broad contours of the immigration system that will replace EU free movement when the transition period comes to an end on the 31st of December 2020. I am not intending on covering some of the material around gaps, but I will potentially address that in the comments simply because I've got 10 minutes and there's a lot to be said, right? So the immigration system that's been proposed seems facially neutral on the question of race. But I think if you dig a little bit deeper, you'll soon start to see that this isn't the case. Race and racism have been constantly invoked in its introduction. Furthermore, when you understand the way in which the new system values potential migrants, you can see the various exclusionary logics at play. And finally, I want to argue, it has the potential to exacerbate racial dynamics in the labor market. So let me just start with a brief introduction to the new system so that we're all on the same page. From 1 January 2021, there will no longer be free movement from Europe, although European citizens can obviously apply for transition to settled or pre-settled status. All migrants coming into the country will be treated the same. That is, EU citizens will be subject to a points-based system that currently applies in respect of citizens from the non-EEA area. Applicants must have a job offer from an approved sponsor, a job that is at least at the intermediate skill level, that is RQF3 or above, and English language skills. The combination of these factors would grant an applicant 50 points. The remaining 20 points, because you need to get up to 70, is achieved by either earning a particular salary, and there's different kind of points allocated to different salary ranges, but the absolute minimum you can earn is £20,500. Holding an offer from a job that's on this occupational shortage list, or having a PhD. So if the applicant is successful, they receive a work visa, but the new entrant must work for that particular employer for a period of 5 years, after which time it's possible for them to apply for settled status and eventually citizenship. Now, it's possible to change employers during this period, although practically speaking, this is quite difficult since you need to be able to find someone that can sponsor you and have met all the sponsorship requirements. Migrants are allowed to bring family members, but the no recourse to public funds condition applies in respect of the all entrants. From the employer's perspective, they must be a licensed sponsor to employ a newcomer, and they must demonstrate that a local worker cannot be found for the role before making a job offer to someone from overseas. So this is in effect an extension of the current Tier 2 route. Immigration policy rarely represents a clean break from the past. Instead, I think it's useful to see it as a palimpsest, where migration regimes build on top of each other. If you look closely enough at a particular system, you can always see the faint etchings of previous policies. The government has indicated that there will be no route for so-called low-skilled workers to enter the United Kingdom come 1 January 2021. An exception to this is the pilot scheme for seasonal agricultural workers that allows up to 10,000 seasonal farm workers to enter the country every year. Now, the industry is lobbying very heavily for this number to be increased to 70,000. And given the influence of the lobby, I think it's reasonably likely. Most of the workers that have already come into the country under this particular guest worker program have come from Eastern European countries, but usually further afield than the A8 and A2 countries, so countries like Ukraine, for example. So in preparing for this talk, I had a look at the status of the Immigration Social Security Coordination EU Withdrawal Bill, which enacts some of these policies. The latest is that the House of Commons, coincidentally, is meant to be debating tomorrow some of the amendments from the House of Lords. Now, Priti Patel has described the new immigration system and recommended it on the basis that the UK is ready to welcome the best and brightest global talent. The immigration system is based on a human capital theory. Essentially, applicants seeking entry are evaluated on the basis of an economistic metaphor that values skill, future income, and asset ownership. Skill, of course, is understood quite narrowly as earning potential rather than the ability to contribute something of value to society. The Conservatives are not the only ones to buy into human capital theory. Human capital theory was very much favored by New Labour as well. In fact, the points-based system for non-EEA migration was introduced in 2007 during Labour's time in government. All this talk about points and skills and the best and brightest has the effect of making the immigration system seem neutral and objective. But you can see that in this formulation of value, that certain modes of migration, and I'm thinking here specifically of asylum seekers and those seeking family reunification, are completely deprioritized. What this system seeks to do is to keep out poor Black and brown people, a policy goal that has a long history in UK's immigration laws. Furthermore, a recent study done by the IPPR found that the new points-based system would have kept out almost 2/3 of EU citizens currently employed in the UK. And that has been another explicit policy goal of the Conservatives. Some might remember Ian Duncan Smith's remarks in 2007 in relation to the EU and migration, when he said, I quote, "We have had a large number of very low value, low skilled people coming through the EU," end quote. Eastern Europeans have become a racialized minority in the UK, a sign that race isn't a fixed category, but rather one that mutates according to political vicissitudes. The government has consistently sought to hide behind technocracy to justify these immigration changes. Many of the proposed immigration changes that we will see when this system comes into force were first floated in a study Theresa May commissioned the Migration Advisory Committee to do. The recommendations in the report by the MAC proposed parity of treatment between EEA migrants and non-EEA migrants and argued that the Tier 2 system should be expanded and its rules liberalized. Significantly, the MAC report suggested a 30,000 salary threshold, which has now been reduced on account of the outcry on the basis of the impact this would have on the NHS. Notwithstanding this faux objectivity, the government has consistently used coded racial language to promote its migration plans. You would have heard the government refer to the immigration plans as an Australian-based points-based system. Some have argued that the descriptor of Australian does the work of signaling racial exclusion, given how the land down under is constructed in the British imagination. As an Australian, I do have to point out that the system only has a passing resemblance to the Australian immigration system. Whilst Australia does use a points-based system to assess candidates under its most common route of entry, it does not outsource the whole immigration system to employers. The state determines who comes in, and once migrants enter, they're entitled to work for an employer of their choosing. The migrants also have a permanent right to remain upon entry, rather than being fixed for a first 5-year period and then having the ability to apply for permanent migration. Let me turn to addressing the immigration plan's likely impact on the labor market. We know that tying workers to certain employers increases their vulnerability vis-a-vis their employer. If a worker is required to work for a particular employer as the condition of their stay in a country, they are less likely to object to exploitative labor conditions. They're also less likely to band together with their fellow employers to resist this exploitation. Hence, the Tier 2 visa fashions precarious workers, to use a memorable phrase first suggested by immigration scholar Bridget Anderson. Some of this vulnerability will be mitigated by the fact that Tier 2 workers are likely to receive a high income and have a reasonable facility with English. As a result of advocacy by lecturers on Tier 2 visas during the UCU university strikes of 2018, the government has now clarified that workers who participate in industrial action would not have their applications for indefinite leave affected. However, the broader chilling effects of having a conditional visa on labor organizing should not be underestimated. An immigration system which chills labor organizing will have the effect of freezing some of the inequities of the labor market into place. You can imagine workplaces or entire industries in which Tier 2 visa holders play a significant role being particularly resistant to the efforts of labor organizers. So just to wrap up, the immigration system that will come into place at the start of next year has been inspired by exclusionary logics, justified using coded racial language, and has the potential to entrench the racial segmentation of the labor market going forward. So thank you very much for your time.
And thank you very much, Manoj, for your, I know it's 10 minutes isn't much to run through a whole new system and the implications of that system on our labour force, but well done. I forgot to mention at the beginning that about your Australian background or connection, so thanks for bringing in those comparisons too. Yes, you're very right, a chilling effect on organising. That this migration policies have on organising and on the ability to demand and fight for better pay and terms and conditions in the workplace. So thank you very much for that. I'm sure that will generate some questions and comments. In the meantime, I shall move on to our next speaker. Our next speaker is Tony Conway. Tony Conway is from Coventry Against Racism. He's no newcomer to campaigning nor to the Institute of Employment Rights. He is Secretary of Coventry Against Racism and a member of the Status Now network group, which is pressing government to regularise the status of refugees and asylum seekers. He is a past industrial officer and remains a member of the PCS trade union. So welcome to you, Tony, and we look forward to your contribution.
Thanks, Cad, and thanks, Manoj, for the very, very important contribution you just made. First of all, thank you for inviting me. As Cad said, it's not the first time I've spoken to an IER event, but it's the first time I've spoken about immigration and migration. I am a local anti-racist activist from Coventry and also part of what's called the Status Now network. I've got about 10 minutes, but first of all, I want to define and probably what we mean by immigration in terms of affecting people in the labour market and perhaps give some real life examples and evidence some demands which I think we should now be building around. The heading, the impact of immigration law on migrant workers, I include within this definition all those who seek or wish to work, not just those actually in work. Also want to mention as well, I think, the way that illegal immigrants, so-called legal immigrants, are actually treated in terms of that. As Manoj said, migrants can apply to work in the UK. Current EU citizens, EEA and Switzerland can come to the UK to work without applying for permission. Citizens of non-EEA countries require a visa. And as Manoj said, for the 1st of January, this will change, apart from, as I understand it, people coming from Ireland. Skilled workers sponsored by their employers received the largest numbers of work visas in 2019. Some 64,000 issued to non-EU citizens. These are mainly graduate jobs. At the end of the year, an estimated 357,400, that's quite a close estimate, non-EU citizens actually had the right to work here and were validly sponsored, but did not have permanent settlement rights in the UK. Permission to work only allows asylum seekers to take up jobs on the UK shortage occupation list. And permission to work expires once a final decision has been made on the claim. There's no right to work. Dependent family members cannot apply for permission to work. In reality, because it's so difficult to actually apply for those jobs, those asylum seekers actually can't work. And many are left in limbo for years. In fact, I've got a good friend who's been applying for asylum now for 9.5 years, living in various hostels around the country. On top of all this, we have perhaps, it's estimated, 1.3 million undocumented migrants. In other words, people who aren't properly known to any authority. And when he was the mayor of London, Johnson actually said there should be an amnesty. And despite there being a powerful lobby, he's refused to act on this statement. The estimate is that after the right to remain expires for EU citizens, some 300,000 people will be added to that list. The Court of Appeal, of course, constantly intervene in this, and most recently, I think it was a couple of weeks ago now, overturned a government decision for someone who'd stayed in this country for a 10-year period, but had a gap in their visa application after the first 5 years. These things happen, as with most immigration issues, because the right to work applies to this as well, because it isn't actually in the legislation, for example, as Manoj referred to earlier on, but actually in regulations. And those regulations can be retrospective. And I'll give an example here. A Bangladeshi chef working in a restaurant on the south coast of England applied for and got another 5-year visa. He'd already had a 5-year visa. The Home Office looked at 2 years afterwards, looked after his particular workplace. And because he worked in an Asian restaurant, they defined it as a takeaway. Takeaways aren't allowed to have people working on work visas. So despite the fact in this particular instance, his employer actually backed him to the hilt, he lost his case. That was applied retrospectively. After 2 years, he'd been given the work visa. Within a week, he was deported to actually Bangladesh, and his employer had to cover the costs. So you can see from that, for many people, it's an uncertain situation. We also need to look at the context of those workers who aren't considered high skilled. And government just appears to have actually changed the definition of wage, again, because of the impact on the health service. It's also a change that was lowered, and it can be changed at any time in the context of Immigration and Social Security Act. But the overwhelming context of that is actually the hostile environment. And when we talk about the hostile environment, quite regularly we think about it as something that applies to people who aren't in work. One of the key aspects of the hostile environment has been introducing citizen-on-citizen papers. So the thing that actually people laugh about, though it's no laughing matter, is people being asked to show their papers for employment, accommodation, banking, driving, healthcare and marriage, and much more. And those people listening might think it sounds very much like the identity cards that government wanted to introduce. And actually, it's worse than identity cards, because in fact, you have to have all those records to prove that you actually have the right to remain. And that's the main reason why ethnic minorities, members of the Windrush generation, have been turfed out of jobs. And I was reading today a colleague or an ex-colleague of mine, she died earlier on this year, Paulette, and she died without receiving any compensation. And that's despite the fact Priti Patel said she was a hero. No compensation, forced out of a job, pension gone, housing rights gone, right to healthcare actually gone as well. And after Brexit, the tens or hundreds of thousands of EU citizens who missed the application deadline will feel the effects. Now, the origin of the hostile environment was actually tied up with the actual rules governing people who were seen to be potentially terrorists. That's where it was first used. And it was the Labour Party, Liam Byrne, who first introduced that definition. But the key movement of the development of that for immigrants was the creation in 2012 of a secret interministerial group to government, initially called the Hostile Environment Working Group. And a wide range of ministers got involved in that. And that's the first time I heard about it, because where I worked at the time, we had responsibility for dealing with some of those issues. But what that meant is the working group came up with a wide range of new regulation and data sharing agreements between government departments, so that a person was deemed to lack evidence of status by one branch of government, like the National Health Service or the police, that information should be shared with various other branches of government too. The culmination of the group's efforts were the Immigration Acts of 2014 and 2016. These acts were not the first piece of legislation introduced privatised outsourced immigration act, but they did expand drastically the new areas of everyday life, The first example in the statute book was privatised immigration controls had been the Immigration Carriers Liability Act of 1987, which imposed fines on ferry companies who carried a person without correct immigration documents. In effect, this forced the companies to carry out their own checks. And that's gone on and on as a consequence of that. The Immigration Asylum National Act of 2006 introduced a new system of civil penalties, which is much more like the carrier sanction scheme again. And the level of fines for employers, originally set a maximum of £2,000 per so-called illegal worker, has now increased in 2014 to £20,000 per worker. Penalties would remain hypothetical without boots on the ground raids on business premises by immigration officials. And I don't know whether anybody heard of Operation Mayapple began in 2012 and invoked high-profile immigration enforcement action in workplaces and around Brixton, London. We've obviously seen that as well on TV programmes, normally on Channel 5 or other places like that. So we've seen these events taking place and posted on YouTube, Twitter and Flickr and other parts of immigration. At the time, the Home Office claimed that a total of 2,000 Indians, Pakistanis, Nigerians, Chinese, Bangladeshis and Brazilians were rounded up as part of the operation I've just referred to. And this is not aimed at Manoj, but actually it's been speculated many times that Australians might be the #1 immigration offenders in the United Kingdom. But it's noticeable that none were reported to have been arrested in the operation. The number of these raids soon increased sharply, the number of penalties recorded almost travelling between 2012 and 2016. With all this publicity and substantial financial penalties becoming a real possibility, workforce culture began to shift. Checking immigration papers for new and existing employees became a routine part of human resource development policies up and down the country that supposedly prides itself on the version of identity cards. So we see this actually taking place now. Whenever anybody applies for a job, they have to prove they have to have the right to actually reside in this country, first of all. Now, it's just often similar situations being played out up and down the country without a victim fortunate enough to find legal aid and take the case to court. We will never know. A small number of cases were later reported when journalists started to show an interest following Guardian reporter Amelia Gentleman's pioneering work. And that's where the Windrush stuff came out. So Windrush was no particular accident rather, it was something that actually did. There's also, of course, the regulations, despite what Patel said, are still in operation. We use the term Windrush, most of us, as a wide catch-all. But there was a recently, I think 2 weeks ago, about an electrician who actually, having worked in this country for 40 years, was then found not to be able to prove he had the right to live here. By the way, he paid tax, he had housing book, he had rent books, but that wasn't sufficient because he wasn't able to prove he had the right to enter in the first place. And he actually then had to take them to court, and eventually all he got was £5,000 compensation, having lost his wages and his right to pension. And as Manoj said, the 2020 Immigration Act will introduce the same criteria for EU citizens, and an estimated 300,000 have not registered to do so. So I'll end by briefly mentioning what I think can be done. Firstly, trade unions must take this issue seriously. It must become a collective issue. It's no good anymore for us to challenge individual cases. We must support the Windrush generation. We must support those people kept up. As trade unions, we must identify what EU citizens have not applied yet to reside in this country and help them to do so. And if needs be, fund those applications if they're low-paid workers, because it can be quite expensive. Secondly, we must campaign to change the law. The hostile environment is actually enshrined in 2014 and 2016 acts. They must be scrapped. But I go much further than that, because status now, with some trade unions are affiliated to, like TSSA and the Bakers Union, for example, we must ensure that all undocumented migrants actually have the right to remain in this country. We must ensure there's humane treatment of asylum seekers. Non-racist immigration laws, which I would argue for, means waking up to our past. We need a single category of UK citizenship, including those who are born or adopted here or have a mother or father here, and a specified period of residence. We talked about 5 years and having the right to actually work there. As the Australian points-based system says, you have the right to apply almost immediately. We must remove the legislation that got rid of citizen rights through previous racist immigration acts. And by the way, all these acts were primarily aimed at people in the Commonwealth. So that's going back to 1962. And I'd finally argue that immigration acts and their regulations must be open to full parliamentary scrutiny, and there should be no arbitrary backdating. Thanks very much, Cad.
Thank you very much, Tony, for that whistle through all the information. Thanks for reminding us of the harsh, unfair and overcomplicated nature of the immigration laws, and for your examples on the hostile environment, including the use of language, and for highlighting the multi-layered nature of restrictions, checks and threats that migrant workers face in this country. And not only that, but then you gave us action points on what we need to do in the future. You're going to have to draft it all up into a blog piece for us, Tony. I know that's given you an extra piece of work, but I'm sure it will be welcomed on our website. So thank you very much for that. And everyone's being so good with their time and brilliant. I will move straight on then to our next and final speaker. That is Dr. Patrick Roach, who is the General Secretary of the NASUWT, the Teachers Union. Patrick was appointed General Secretary of NASUWT in April of this year. He having previously served as Deputy General Secretary for the past 10 years. Before that, Patrick was a teacher of politics and sociology and further education, and a researcher and lecturer in education, social policy and equalities in higher education. But for this instance tonight, Patrick is here because over the next 18 months, Patrick will be chairing the newly created TUC Anti-Racism Task Force, which will hear from Black workers about their experience of everyday racism at work and set out the action needed to address structural discrimination and disadvantage. I believe, Patrick, members of the task force will include senior leaders from across the trade union movement and society organisations, and will be investigating the systemic discrimination BME workers face. But I'm sure you'll tell us all of that in your presentation to us, and thank you for joining us tonight. Over to you, Patrick.
Oh, well, thanks very much. And it is very much a pleasure to be addressing this event this evening. And as has just been said in that very generous introduction, you know, I'm chairing this TUC anti-racism task force, but you know, also in my day job, it is to lead one of the UK's largest trade unions, the NASWT, the union representing teachers right across the UK. And so, you know, it's extremely important, the issues of tackling racial injustice in the labour market for me, for my union, and indeed for the entirety of the trade union movement. And I want to pick up on the points that both Tony and Manoj have said in their remarks. This is very much a hostile environment for Black workers in this country, more likely to be denied fair access to employment, more likely to be made unemployed, more likely to be in insecure employment, working 0 hours contracts and with fewer rights at work, more likely to be paid less than their white counterparts, less likely to be promoted into a senior position and less likely to be promoted at all. More likely again to be subject to competence procedures and to dismissal, irrespective of qualifications or experience. And Black workers, we know, over the last number of months during this pandemic have been 3 to 4 times more likely to be killed at work as a result of the coronavirus. And of course, with this government's immigration agenda, Black workers are more likely to be employed at the mercy of exploitative employers and less able to challenge unscrupulous employer practices for fear of losing their job, their home, and their rights to be in this country. And as Manoj was saying, new immigration rules which will create a further cadre of workers from overseas who have fewer rights at work, less opportunity to challenge unfair and exploitative employment practices, and all the while facing the threat of deportation. And as we navigate through the coronavirus pandemic, who is paying the price? Well, the facts are very clear. Black workers have been asked to shoulder more risk during this pandemic. Black people are more likely to be in insecure and high-risk jobs. Black staff are at a higher risk of COVID-19 exposure and job loss. And TUC has been reporting during the course of this crisis on the experiences of Black workers. And just let me quote a few of those statistics, that Black workers find it harder to assert their rights for a safe workplace with adequate protective equipment. They find it harder to shield if they or someone they live with has a health condition that puts them at higher risk of COVID-19. And they find it harder to take time off for childcare responsibilities if, for example, schools or other childcare providers close. And intersectional inequality and discrimination is also a concern. 1 in 8 Black women are in insecure jobs compared to 1 in 18 white men. Black workers have been overrepresented in jobs with higher COVID-19 death rates. And we know that deregulation and the lack of robust enforcement has created scope for bad employers to discriminate with seeming impunity. In the teaching profession, no exception in relation to this. The NASUWT, my union, has found extensive data and evidence from our research, from our casework with members, both individual and collective, which indicates that few schools and college employers have considered race equality impacts of their decisions. We found that risk assessments in schools haven't been equality impact assessed. And we found that Black teachers are significantly more likely to report being threatened by their employer, school and college employers, threatened by them with disciplinary proceedings or job loss when expressing concerns about returning to the workplace when compared with their white peers. But according to the government, and we've pressed the government on this, according to the government, it's not in the public interest to publish its equality impact assessment in relation to its response to the coronavirus pandemic and its decisions on the reopening of schools. And even the Equality and Human Rights Commission has failed to act when we've called upon them to do so. And as Brexit looms, we know who will once again be targeted as workplace rights continue to remain under threat. And so, colleagues, these are just some of the symptoms and products of a racially divisive, hostile environment policy that's being peddled deliberately by this government. And the answer is about tackling workplace injustice, quite honestly, as Tony said earlier, by organising, focusing on securing progress through our collective endeavour, through collective bargaining, by taking collective action to challenge exploitative employment practices, as my union has been doing. We've got to focus on organising and campaigning publicly, locally, nationally, and I would say internationally too, to expose and challenge racial injustice at work. And who knows what the outcome of the US presidential election will be, but the impetus, the importance of making those connections at a global level with our sisters and brothers in other trade union organisations and civil society organisations in the fight against racial injustice is more important now than it's ever been. We also need to focus on tackling insecure employment. We know that 1 in 6 Black workers are employed on insecure terms and conditions. And that, of course, makes employers more confident to discriminate with relative impunity. So we have to focus on how to ensure that employers and government are held to account with strengthening legislation, the Equality Act, labour market legislation and regulation. We have to focus on enforcement, We have to focus on organising in the workplace, including ensuring that racial justice is central to our trade union organising and campaigning priorities. And so in that context, the TUC's Anti-Racism Task Force is going to mark the start of yet another important chapter in the trade union movement's fight against racism and racial injustice at work. The task force, in my view, will be a force for real change. And it was launched in September, and it will be led by trade union leaders and by black workers. It will take forward a comprehensive and coordinated programme of work to tackle racism and racial injustice and to deliver fairness and decent treatment at work. It will be overseeing a comprehensive programme of research and evidence gathering, and I trust that we'll be able to work closely with the IER in that endeavour. It will be evidencing the scale and impact of institutional and systemic racial inequalities across the labour market. It will agree priorities for union organising and collective bargaining to advance racial justice at work, and it will agree actions for unions and the TUC to take to increase representation of black trade union members at all levels of trade union democratic and employment structures. Now, 20 years ago, the TUC launched the Stephen Lawrence Task Group, and that was set up to root out racism at work. But we know from Baroness Lawrence's report of just a week ago that we still have work to do. Giving voice to the everyday racism that black workers face, setting out our plans to confront institutional racism and discrimination at work, and most of all, leading by example. And we'll do that, colleagues, through the work of this task force. And as a movement, we'll also be giving notice to government, to employers, and to regulators that we will hold them to account. Thank you very much.
Thank you very much, Patrick. Thank you for that very important contribution and for informing us about the work of the TUC task group. We look forward to watching its progress, and clearly the Institute would be more than happy to work with the task group and with yourself to put that work into action. We at the Institute, we have our own project developing at the minute on race at the work. We are picking out themes that we developed in our manifesto of employment law. We know there's another 4 years before that will be seen again as a policy initiative, but we are developing themes that we took there to fill the gap on some of the policy procedures since then. And well, I don't know whether you do know, but collective bargaining we see as being central to winning not only the end of precarious work, the improvement of pay and conditions, the better involvement in terms of women and race and anybody facing discrimination and precarious work. So thank you very much for that. I will now turn to some comments. Well, the comments across chat box and on Facebook are very welcoming to all your presentations and have clearly gone down very well. Let me see what I can find. There's lots of comments there outlining the work of the Institute with links to our work. There's one, there have been numerous government commissions, reports and recommendations in the past, as have been raised by all of our speakers. How do we best ensure that those recommendations are turned into action? Is one comment. There is something there on in a consultation earlier this year, maybe this one is to Manoj. There is consultation earlier this year where the government proposed establishing 10 free ports. We wonder the impact that those free ports will have. We have seen the existence of export processing zones across the world. None of them deliver the kind of secure, well-paid jobs that we would like to see here. The fear, of course, is that those export processing zones will be seen as the growing sectors of our economy, sectors to which the government has just announced they will create 4,500 new work coaches to encourage people into work. Now, when you see those kinds of developments and weaknesses in the benefit system, you wonder if we are going into worst era of jobs and what we can do about that. So, how do we turn past recommendations into action? And is this a double blow with the creation of free ports and the export processing zones? Who would like to start? Patrick.
Yeah, I'm happy to certainly pick up on that first question, past recommendations. Whether those are past recommendations that focus on the government, on employers and regulators, or indeed on trade unions themselves. I mean, the fact of the matter is that we've got to be absolutely clear about what those commitments have been. And we've heard too much in the past, particularly from governments, successive governments, in the space of their avowed commitments on racial justice. And we've seen precious little by way of clear action. And it's vitally important that we do remind governments and indeed other bodies of what those commitments have been in the past. And that's one of the things that the task force is going to be doing, which is part of the evidence gathering process that it's going through as its first piece of work. But we've also, I think, got to be campaigning around not only what those recommendations were in the past, but what recommendations we want to bring to bear now. And we've got to campaign with urgency. We've got to identify who our partners are as trade unions, and we've also got to organise in our workplaces, and we've got to bring our members with us on that journey. Because you know what? If we haven't got a government that is on the side of working people, we haven't got a government that's on the side of decent working conditions, haven't got a government that's on the side of fair employment practices and the ending of precarious employment and 0 hours contracts, then it's going to be doubly difficult for us to deliver racial justice in the workplace. So we've got to organise with our members to ensure that what's important to us industrially is also seen as important politically as well. And we can't lose sight of that. I'm not looking to politicise or to be partisan about this, but if we haven't got a government that's on the same page as working people, then that challenge in respect of securing racial justice in the workplace is going to be even more of an issue for us as individual unions, for our movement, and for civil society organisations as well. That's an important part of what we've got to do. It's about organising.
Brilliant, thanks for that, Patrick. Manoj, did you want to say anything about the free ports?
Yeah, sure. Yeah, I'll leave the other matter for the more experienced campaigners and activists to comment on. And I think, Caroline, you sort of gestured to this as well at the start of introducing me, which is what's happening with trade, the trading system that will come to replace trade with the European Union, right? I think we get very focused on immigration when we talk about movement of workers, but the trading system also allows human mobility, but it doesn't characterize it as migration. It characterizes it as trade in services. It's a particular category of trade in services. So I think we need to be very careful when we look at what the government is planning to do with trade agreements, because what the suspicion is, and there's a short blog post I wrote with my colleague Tonya Novitz where we're trying to sound the alarm about this, which is essentially arguing that the government is probably likely to use the trading system to bring in additional workers, but characterize it as trade in services. So they get to fulfill their political commitment to cut down on low-skilled worker migration while still keeping their friends in business happy. And I think it's something we need to be aware of. Now, the trading system obviously intersects with this plan for free ports, which is very shadowy and we know very little bit about. There's been a consultation paper and it uses very, language like regulatory standards will be changed, but no one's quite clear what those regulatory standards is. And there's a real fear that you could end up creating export processing zones where labor conditions don't apply. And we don't know what's going to happen with that yet. COVID obviously put a stop to the government's plans, but there is still a lot of pressure building. I was reading actually over the weekend a document from the Policy Exchange, the right-wing think tank that seems to have a lot of influence in the government, arguing that they need to move forward with full speed on this issue of the free ports. So that's still in the background, and we just need to watch to see what's happening with that, but it's not something we should be ignoring at all.
Thanks for that. Somebody has to read those think tank reports, so thank you for doing it and for extracting the dangerous points that are in them. I'll move back to the chat box, and here's some questions, one each, very egalitarian, from Kelly O'Dowd. She says, can Tony give us some ideas on how we could encourage trade unions to work together on tackling the hostile environment policies? And one for Patrick. Can Patrick talk about organising black teachers during the pandemic? She notes that, you know, some trade unions saw their numbers go up in numbers during, as reps came forward to assist in the workplace. And Manoj, you got one too. Can you explore what is meant by employers having to offer jobs to people who are resident first? So, Tony.
Yeah, thanks very much, Cad. Well, two things really I want to say. You asked a question earlier on, which I don't think has been answered, about recommendations coming from government or other reports. I'm fed up with reports being written on racism within this country, because they've been going on for decades, if not longer. But I would ask all people on this call to have a look at the Williams report into Windrush lessons. She made 30 recommendations in that report, and she tracks back there to the 1971 Immigration Act, which actually said that all Windrush citizens had the right to live in this country. But as I've explained already, they didn't have the ability to prove they had the right to live here in the first place. I know that for a fact, because I had two members as civil servants working for the Ministry of Justice, no more, no less, who suddenly lost their right to work in this country. They weren't sacked, they were told they had no right to work. And it took them some 2 to 3 years to appeal through that process. So I would go back and look at those recommendations and ask Priti Patel why, despite the fact she's up in the House of Commons and said, I will implement all the 30 recommendations made in that report, why she is yet to do so. And that brings me on to the second question. I think we have to explore experiences. So if, for example, we're dealing with particular cases to do with immigration within our workplaces, we need anonymously to produce that. Now, I know that the Trade Union Campaign Group, I think it was just before TUC, produced a pamphlet which explained some of the experience they'd had about actually tackling racism. It's a very good pamphlet. It can be downloaded online, and that gives people an idea what could be done cooperatively. But I'd also say, and it's probably a question I would think, Patrick, to the TUC task force, because one of the things I think that the TUC task force must try and do is try and get unions to work together to tackle the hostile environment in the workplace. And the first way we need to do that is actually to educate our members and our reps about what we mean by the hostile environment. Thank you.
Patrick.
Yeah, can I just pick up where Tony left off? I mean, I'm sure that's absolutely going to be central to what we do. It's got to be, you know, being part of the TUC is about recognising that we can be more than the sum of our individual parts. And actually, when the movement comes together, it can be an extremely powerful force for change. And so, you know, that leadership of that anti-racism task group, it is as much about what individual constituent affiliated unions bring to the table as it is about how unions affiliated to the TUC can work together to utilise their leverage to bring about real and sustainable change within our labour markets and within society at large. And I think that's going to be an extremely important opportunity, I think, for us as a movement over the course of the next year and a half to 2 years. In terms of how we bring black workers, in particular black teachers, together and mobilise. Frankly, I've never had an issue about mobilising black workers or black teachers. The issue is about the recognition that actually we're a union, whichever union we are, we're a union that stands up for and is prepared to speak out on racial injustice, and will stand up for black workers. We've got to actually carry that proudly as part and parcel of who we are, how we define ourselves, and how we go about doing business. And of course, in the context of this pandemic, and frankly, it's disgraceful and outrageous handling by government, which has been in complete denial as far as the issues around racial disparities are concerned. That presents, dare I use the word, an opportunity for us to engage with black workers, because it is clear that black workers are disproportionately losing their lives. Black workers are disproportionately now losing their jobs and their livelihoods as a result of the economic downturn and recession, which has been sparked by the pandemic, but also sparked by the way in which the government has managed the situation of this global pandemic. And if we're speaking to black workers about the issues that matter to them, if we are determined and deliberate in our actions to bring black workers together, then there is very little difficulty for unions to really engage and to mobilise black workers. But the real challenge, a bit like Tony was saying there about unions working together, and all the challenge for us as unions is getting all of our members to work together, to get all workers to recognise that challenging and tackling racial injustice in the workplace is about justice for everybody at work. And that's clearly got to be one of the key issues that we need to have centre stage as part and parcel of the TUC's task force's work of how we organise all workers around racial injustice and standing up for the rights of black workers, women workers, lesbian and gay workers, disabled workers, and so on. Thank you.
Thank you very much for that, Patrick. I don't know, Manoj, if you wanted to if you had something to say before I close up our event this evening.
Sure, I'll just be really quick. So at present, there aren't huge numbers of tier 2 workers coming in every year. And that is because an employer, as I said, has to be a sponsor and has to demonstrate for that particular job that no local person can be found, and they have to go through a bit of a rigmarole to do advertising and demonstrate that there is a suitable local candidate. I cannot see the government relaxing those rules. I think given the view that they've expressed that rather than looking for people overseas, employers should be hiring people locally, as also given the high unemployment rates that are likely to result from COVID. But I think there's a real mismatch between what the government thinks will happen and what will happen. And that's because they don't seem to understand that workers cannot just essentially relocate to where the jobs are, that they may not have the correct skills, and there's no government effort to improve people's skills. So there are all sorts of problems with the government's theory on how they think the labour market's going to operate and how it operates in practice.
Thank you very much for that, Manoj. Well, it's always the way. We've run out of time. And now we'll go so quickly on these events, but I still have 1 minute maybe to say, if you have liked this event tonight, please do register for future events. We've got our very popular employment law update events coming up soon. That event's not free, although I will say it is cheap, particularly when you think of the level of experts that we give presenting those events. So please sign up. Watch the website for future things. There will be a final slide at the end of this where you'll get all the contact information you need. log into the website, sign up for our news brief. We hope to see you at future events, but just for now, I would like to say a very big thank you to our 3 speakers. It has been phenomenally interesting, very informative, and just what is needed at this moment to give us that fight back in spirit to make sure that we get out of COVID, out of this pandemic in a better place. So thank you very much for joining us, and we look forward to seeing you in the future.